Let me address the Secretary General now. We've heard of all those initiatives, which are really very important. What do you plan for the immediate future at the level of judicial system, and how is that linked with the funding from the RRF? Thank you for the invitation. As Jan Stavropoulos said, I wear a double hat in this meeting as a member of the cabinet, but also my 20-year experience from courts in law at large. I am glad for discussing such an issue, which is not only topical, but also has been long-standing, because all the factors involved in justice, and this includes politicians, judicial system, judges, lawyers, ourselves, and public administration, a lot of efforts have been made, but at the same time, we've got contrasting opposite forces. So this long-standing problem, the daily experience of the citizen and the companies, which is not the best, the need for modernization, but also the fact that we should not ignore that all, with no exception, the recommendations of international organizations vis-à-vis the indices for the development show and demonstrate the justice as one of the fields that must be fully rehabilitated, revamped, led us to have a separate sector. When we speak of RRF, it's not merely a funding instrument as we might have it in mind. Of course, we secured 700 million euros for infrastructure that you mentioned, for training, but we also wanted to include also reforms that are connected with the disbursement of those funds, so as to have the self-commitment of the Greek state, not a government, but beyond one electoral mandate, that some things will be done. And before coming to the basic reform for me, as far as I'm concerned, which is related with the RRF, which is the restructuring of the judicial map. Let me say a couple of things that are currently connected with this reform vis-à-vis what we have at hand. And those of you who are from companies, you know that we'll be having hundreds of calls for tenders in the next 9 months, so as to quickly absorb the resources from the RRF. And we examine ways such as to have only one stage of the appeals examination, at least for some projects that will be integrated in the fund, so as to broaden perhaps the fees, but not creating problems in the competition or the eventual creation of cartels, but also have a kind of point system which may have arbitrary appeals to impede competition so as to accelerate the whole process. So let me come here to what you've asked about the RRF. Restructuring of the judicial map, because for me personally and the government, the immediate future is of paramount importance. First and most importantly, this is the most important and difficult reform. Most important because it consolidates the main reformative goals for the immediate future: digitization, human resources, rational breakdown, how many judges, how many courts, how many clerks, and all that in a coordinated and rational way. Second, it's more difficult because the agencies who have led to the problems are deeply rooted. Obviously, political forces, clientelism, corporatism, all these have led to such phenomena. To have that is currently 63 first instance courts and 9 second instance courts, 14 second instance courts scattered all over the country. For instance, in Germany, with 80 million inhabitants, they have only 20 second instance, and the Netherlands have got 5. Taking into consideration, of course, the geographic disparities. But in public administration as well, the first and second instance courts are definitely above the European average. Whenever there was a problem, there was an increase of cases in administrative court, we would establish a new court. Of course, this has huge irrationalism in its organization. So through the new map, which is currently planned and will be implemented from 2024, we introduce specific indices so as to control the flow of cases, to know where we need judges, where we need more clerks, how we should proceed with this flow, and to know, if need be, to make some mergers or changes in the judicial map of the country. Let us not forget that to a large extent this map was established because it served communication, the road network, technology had not progressed, but this has changed. So for us, in the immediate future, I would say that restructuring, review of the judicial map is of decisive importance. Thank you.
Something to the Secretary General for the coordination of the government. We live in an era in which technology evolves really fast. New solutions, new applications, new services. These instruments become part of our daily lives more and more. Do you feel that Greek magistrates and Greek judges are able to catch up with that and they fully understand what this evolution is about, and especially when there is a case related to these avant-garde issues? How well do you think he or she has understood the evolution of technology itself so that the magistrate himself or herself may administer justice? In a nutshell, let me link that to the previous comment, the redesign of our judicial map. What are the judges, what are the clerks, etc. Let me put aside the school of judicial police or judicial clerks. These are very important initiatives by the ministry that will support the work of our judges. Let's talk about the judges themselves. Following the changes already introduced, we have in the National School of Judges, we have new courses, protection of personal data, new technologies, energy, environment, digital and soft skills. And let me come back to that because for me it's very, very important. And as the minister said, there will be a mandatory post-vocational training so that the magistrates currently in service will be able to meet the expectations, and this will also be a criterion for their assessment and promotion. There's a very important reform which will start delivering after 2 judicial years, because we will now have the judges feeling the pressure by this inspection of judges or assessment of judges. For me, the most important thing, administration and actually, let me put it in other words, many judges in their lifetime will be asked either to run a bigger court or a smaller court or a unit or a formation of courts. So they will have to have the administrative adequacy, which hasn't been part of their curriculum in the past, in order to say, okay, these are the cases at hand. They should be appointed to this or that judge. Who is the right judge to hear this case? To try this case. Maybe this colleague of ours is in a difficult state. Let's pick someone else. This calls for some administrative adequacy, plus the skill to properly evaluate the data you get for your court. The minister said before that we had to manage the Katselis law cases, but we didn't know the number of these cases when we took office. It took us a lot of effort to find out the accurate figure, the number of these cases. So thanks to the statistical agency, we will be able to support both the redesign of the judicial map and support our judges, because those who are experienced know what I'm talking about. If a good judge takes on a case, you're going to get a good ruling, and so on and so forth. So training, post-training, new rules, and the fact that we link that with the judges' evolution and promotion makes it obligatory for those who, even they don't want that, they will have to follow this course. So ending, because I understand